Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On March 30th, the court heard arguments in Viking River Cruises versus Moriana, a case which concerned whether the Federal Arbitration Act requires enforcement of a bilateral arbitration agreement, providing that an employee cannot raise representative claims, including under the California Private Attorneys General Act, also known as PAGA. With a decision likely to be rendered in the coming weeks and months, I am joined today by Theane Evangelis, partner in the Los Angeles office of Gibson, Dunn and Co-Chair of the firm's Global Litigation Practice Group.
Thank you. I'm thrilled to be here. Well, it was a very lively argument. It did not disappoint, and former U.S. Solicitor General Paul Clement argued for Viking, and public citizen Scott Nelson argued for Moriana. And what was really fascinating is that there appeared to be three justices who were focusing on issues that the Supreme Court had already addressed in Concepcion versus Epic Systems. Justices Kagan, Sotomayor, and Breyer were skeptical of Viking's argument that Supreme Court precedent interpreting the Federal Arbitration Act prevents states from choosing to outsource labor law enforcement to private attorneys. But while they were clearly against Viking's argument, it seemed that a lot of the principles they were focused on were arguments that the Supreme Court had already rejected in Concepcion and in Epic Systems. So that was interesting to listen to this argument, because it seems like this ground was already covered in those earlier cases, and that they should apply here in a way that supports Viking River's position. So Justice Sotomayor, for example, at one point told Mr. Clement that she was having a series of problems with all of his answers. But again, he repeatedly explained that the FAA does impose limits on the state's ability to outsource labor law enforcement to private attorneys, and that the Supreme Court had already held that the state does not have the ability to undermine arbitration like this in those earlier cases. For these three justices, they seem to keep circling back to the question whether PAGA was intentionally crafted to evade arbitration under the FAA. And Justice Breyer at one point seemed to suggest that whether the FAA preempted PAGA depended on whether PAGA was neutral or intended to prevent claims from being arbitrated. And it was an interesting and lively discussion. And I would say those three justices really did take up much of Mr. Clement's time. Three Justices Barrett, Alito, and Kavanaugh, through their questions, seemed to be quite skeptical of PAGA. And from their questions, it sounded like they were more of the view that the FAA might preempt PAGA. Justice Barrett's questions suggested that California's choice to enforce its labor laws through PAGA is no different than a choice to enforce them through a class action mechanism, and so shouldn't be afforded any greater deference. And of course, PAGA is, and Viking River's main argument here was, or one of them was, that PAGA is really just like a class action. If it looks in every respect like a class action, but it isn't, and that really shouldn't change the outcome just because the state has created this novel procedural mechanism. Justice Alito's questions suggested that he agreed that PAGA is a class action in disguise, and Justice Kavanaugh also seemed to be concerned that California is an outlier, and he um, picked up on the fact that no other states had filed amicus briefs supporting California, and so in rebuttal, this was an interesting point uh, that Mr. Clement hit. He said if the outcome of this case were truly a great threat to other types of litigation, like shareholder derivative actions, ERISA actions, qui tam lawsuits, you would have seen other states and the United States being active in this case, supporting California, but that didn't happen. So it really seemed to suggest that California is an outlier. And for his part, the Chief Justice seemed to be focused on the structure of PAGA, and he was really trying to probe whether PAGA is like a qui tam action or a class action. And it seemed like his questions to Mr. Nelson suggested that he viewed PAGA as a stripped down class action. And so he was also very much focused on that issue and whether the state can somehow exempt PAGA actions from the FAA does in many ways, that the answer to that question is informed by what PAGA is. So there was a lot of that going back and forth where the justices were really grappling with what is PAGA and how should we think about this? Because as we all know, it really is a bit of a Frankenstein statute and it's unlike anything else. And so that's a really important piece here. Justice Thomas also did ask a question about whether um, the FAA. It seemed to suggest that he was thinking about whether it should matter that this case came from state court. And he has in the past said that he does not believe the FAA applies to cases in state court. So that's an issue that will be interesting to see where he comes out on this. Justice Gorsuch was quiet. He didn't ask any questions. So it's unclear where he is. He was listening and didn't ask any questions. So the justices also seem to disagree about whether PAGA, once again, going back to what is PAGA, whether it's a procedural or a substantive law. And throughout the argument, you'd hear Justices Kagan, Sotomayor, and Breyer consistently referring to PAGA as a substantive law. And Mr. Clement pointed out that the California Supreme Court described PAGA as a procedural law in amalgamated transit. But later, in response to a question from Justice Barrett as to whether that should end the inquiry under Erie, he suggested that the Supreme Court could disregard the California Supreme Court's characterization of PAGA and really that the court should come to its own conclusions about what PAGA is. So there was also some back and forth, and Justice Alito also got into the discussion about really does it matter what California says about this law and how they describe it. And so it will be interesting to see if the court agrees with Viking River's view of PAGA and what it is. And in rebuttal, Mr. Clement argued that there's no such thing as a PAGA claim and that PAGA is simply a vehicle for substantive labor code claims and collecting penalties for those claims, which for those of us who are in California and deal with PAGA claims frequently, like myself, we all know that's the case, that PAGA really is a vehicle for collecting penalties on those claims that are underlying the action. So it is not itself really a substantive law, but rather a procedural vehicle. So when we take a step back from all of this, it seems like there were probably 3 justices who are skeptical of Viking River's arguments here, but it did not sound like there was a majority who were of that view. It seems like there were several justices who were supportive of Viking's position. It's always, of course, hard to predict how these things come out, but from the direction of the questions, it seemed like there was quite a bit of focus on really what is PAGA, how do we understand what it is, and uh, and from the interesting thing was listening to Justices Kagan, Sotomayor, and Breyer, so many of their questions seemed like questions that were asked and answered in Concepcion and Epic Systems. So if that is true, that really tells us something, because those cases should control the outcome here. So I'm interested to see what happens. It will be a very interesting opinion to read, I am sure.
Great, thanks. Do you have any sense on how this might affect arbitration, both in California and perhaps more widely going forward?
Well, there are thousands of PAGA claims filed every year in California. PAGA has become the new preferred vehicle for plaintiffs bringing suits in the employment area and wage and hour cases. They really have supplanted class actions. So I think it will have a tremendous impact on what happens going forward. Will this continue to be a means for evading the enforceability of class action waivers, or will PAGA actions finally be recognized for what they are, which really is a class action in disguise? If the Supreme Court rules for Viking River Cruises here, I think it will have a very big impact on what we see going forward in California, and whether these sorts of claims can be aggregated in this fashion in a way that clearly circumvents the arbitration agreements that are in place in many contexts. So I think the impact really will be tremendous, but it's unfortunately it has been a way of evading the already existing principles. So this case really doesn't raise many new issues. It's just about applying existing precedent to an area where it should have been the case that it applied already.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.